Hi, everyone. Good evening. Carl Steinbeck here. Day 31 here, Wednesday, the 11th of June, and another crazy wild day in court there in Denham, Massachusetts. Commonwealth of Massachusetts versus Kieran Reed, a murder case, secondary murder case. And we have another day of implosions by the prosecution. The lead prosecutor, Brennan, did a terrible, absolutely terrible job today, and we'll get into that. But another ARCA expert, Dr. Andrew Rentschler, he was phenomenal. He was able to withstand this browbeating, demeaning treatment by the prosecutor, and he excelled and completely demolished and crushed the ridiculous testimony of the prosecution's expert, who has the same similar type of degrees as Dr. Rentschler, but Dr. Welcher, he was completely obliterated in this court today. And no matter which way Brennan tried to trick and twist stuff around for this Dr. Rentschler, he was totally able to anticipate and deflect and stick it back on Brennan. In fact, Brennan was completely going down the tubes here because he was actually making the case even stronger, things that Rentschler was not able to be testifying to on direct because Brennan would have blocked it with an objection and a sustained by the judge. He actually wound up bringing out more stuff, and that's why I'm saying he lost it, and he's lost the case as well. I mean, I've been saying that for a long time now. It's game over, and just because you can't act like this guy and berate people, treat them like trash. These are highly qualified professionals, all these doctors, and just think about it. He's just going up there and just, I mean, he might as well literally spit in their face. That's the kind of contempt and disrespect he has for these people. So you think a guy like that's going to win a case? I don't think so. And it's been really hard to watch this abuse of process by, as I've said many times, this sham court, and it makes your blood boil, and you get steam coming out of your ears because I can't take this. I mean, I've seen enough railroading in my life, but this is like far beyond what I've ever seen before, and it's this is on worldwide coverage. Anybody that wants to see it, and so these people can't help themselves. They're that mean and vicious that they can't even act like they are trying to impose due process, and that's what's really shocking. So, you know, that miserable people like to make others miserable, and miserable people in charge of courtrooms and prosecution offices, those are think about it, these people are that miserable in themselves, and they actually self-loathe themselves that much to bring out this kind of ridiculous behavior. And it's actually juvenile behavior at that. There's no adult supervision in the DA's office or in this courtroom by anybody sitting up there on that bench either. So it's really something that I wish I didn't have to see. I never thought I'd see something like this before. I've seen a lot of trials, been part of many trials, both civilian and military. I've also done federal criminal defense work as well as federal prosecution work. So generally, jurors are the same wherever I go. I believe that if you are credible as an advocate, you bring the facts, you do your homework, and you lay your cards out on the table and you have nothing to hide, you're not pulling any punches, you're not trying to trick and bamboozle the jury, then you really should win the case if you've really done your homework and you know the person is in fact guilty. So I'd say as a prosecutor, as an attorney, I've had everybody go to jail that I've prosecuted. So I like to think that's because I was fair about it. I never had a defendant or their attorneys fuming mad at me because I had blocked so much of the evidence they've tried to present. And so, yeah, it's very much an issue that this is hopefully going to have a long-lasting effect on the massive amount of corruption in that tiny little state, aka Commonwealth. It's uncommon wrath, is what it is. Uncommon wrath of injustice, abusive process, and just despicable, corrupt behavior by so many people at so many levels. I don't know how you people that live there would even stay there. Now that you know how bad it is, I, as a matter of moral principle, would never want to pay taxes again in that state. I would sell my house, get the heck out of there, and I'd be darned if I'm going to sit there and give these atrocious people $322,000 for salary. Multiple cops are making that kind of money, 230 to 322. That's such a insult to the taxpayers. They're living like kings and lords up there, and they're treating their people like just peasant serfs and just trample all over their rights. I mean, this is worse than it was what we fought the Revolutionary War over back in 1775. And so think about it. That's where many of the founding fathers were. John Adams is the one. Thank you for the person that sent me the email, a gentleman up there in Massachusetts. I forget your first name, but you remind me of John Adams. That's the one I was trying to think of. And he's right down the road. I forget which town you said he's from, but it's just, I think of that a lot. It's like, gosh, I used to have this as a kid growing up, reading about the Revolutionary War. I thought, wow, what awesome people that had the courage to fight the British off. And the British just came in and just exploited the people so much. And that's really what we have here is exploitation. Keep in mind what the British troops could just come over, take over a house, kick the occupants out, eat all their food, kill all their animals, slaughter everything in sight to feed themselves, and not have to pay anything in return. So that's what really started the whole revolution, and the people decided to get the government off their backs because the government was way bigger than the people, and it should never be that way. The government should serve the people, not the other way around. So it's this is an example of basically an aristocratic, corrupt monarchy of sorts. And so anyway, I just think a lot about how can it do. I know we're celebrating here the Army, which I'm a retiree of. The Army is going on 250 years old now. So the Army, U.S. Army, is older than America. So we've been around since 1775, and so that's years before we became an actual constitutional republic. So anyway, I'm just thinking, reminiscing about some of the history there and how far this thing has gone down and turned into a cesspool of disgraceful conduct that is not about justice. So anyway, if you don't respect your freedoms and liberties, and you don't elect people that really want to do the right thing and have the people's best interest at heart rather than their own crony political agendas, then this is the kind of stuff that can happen. So I don't know if they're going to be able to turn around there, but I, for one, I would vote with my feet if I lived there, and do like Brian Albert, put the house up for sale, even if I got to lose $50,000. So anyway, anyway, that's my take. Otherwise, you guys if you do stay there, you better be active in politics and run these crooks out of the government positions they're in. There's some good British. Yeah, there are some good. It's not the people, it's the governments that always cause problems, right? It's always our governments that cause problems, and the politicians usually are the ones leading that, right? So anyway, let's go ahead and jump to the trial here. I don't know if I'll cover all of the direct because I want to make sure we get all the cross. It was amazing. Another amazing day of Brennan implosion. All right, so I get up to 24 here. This is continuation of Dr. Andrew Rentschler of ARCA.
3 questions. Were you all able to instruct here?
Golly.
Dr. Armand, you're still under oath.
Yes.
Thank you.
Good morning.
Good morning, Your Honor.
Didn't say good morning, Dr. Rentschler, just good morning. So
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Rentschler, good morning.
Good morning.
Yesterday, when we
Never.
last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review
yeah.
certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
Thank you. That'll be KK for ID.
To bring up the PowerPointer. Want me to bring up the PowerPointer?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here. There we go.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer. Ask the question again.
Sure. Did you seek to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Sustained.
Who cares?
Ultimately, were you in receipt of a
Get on with the
PowerPoint
trial,
presentation
Judge.
and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
So I'm going to see you both at sidebar for just
Yeah,
a
another
minute,
sidebar.
please.
My gosh. Started 24 minutes late. Held the jury up 24 minutes, and then you're going to do this as well. We just started. Again, obstructionist of justice here. Look, he's not looking at the jury. He's in his own little world. He has no clue. He's completely clueless about how he's coming across. That he's turned into the most meanest, nastiest attorney you could ever find on the face of the earth.
May I?
Yes.
Did you undertake to review analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis that was undertaken after you reviewed the aperture reports and aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those three separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank you.
Correct. This is injury reconstruction biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual.
Really breaks it
opinion.
down
And
good.
describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely. Yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which you know, it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. O'Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation.
Professor,
you have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle. We ran.
Except it wasn't science, Tina. As the doctor here stated today, that's not science. That was just an absolute farce.
Into it to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case? So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis. And that's what's important. You know, I have 3 kids. I have a 9-year-old who's actually.
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example?
You know what? I keep wanting to say Belcher. Welcher, he could sit there ramble on all he wanted, and he's not even rambling. He's just making great teaching points like a professor. And he wants to bring up an example about one of his kids. Now watch what happens here.
That you could use of sort of a real world example that you might want to use to explain
Real-world example.
some or part of the scientific method.
There is, yeah, and I would like to explain an example of what's important with that. So I was going to say I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai! And I have 2 older ones.
All right. We're going to stop this. Another example.
All right, we're going to stop this. You got to be kidding. So Kai, happy birthday to you. I apologize for this judge treating your dad so disrespectful. He's just trying to do a nice little shout out to you for your 10th birthday. Your dad obviously missed your birthday party today, so it's embarrassing to see this, but what an awesome, not only expert in his field this guy is, but what an excellent, outstanding father he is as well. So shame on the court for shutting this down.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honor.
Oh, okay. But the prosecution's expert, Dr. Wolf, can talk about how he drives home to make his wife coffee every morning, right? But that's not a problem for this court. It's just a guy like this wanting to give a shout out to a little 10-year-old on his birthday. Unreal.
Go ahead.
Details matter. Okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen. Okay? As an expert, I can't come in and just say.
Sustained. It needs to be more question and answer.
Why do details matter?
You know what? That's not the way good attorneys do it. Good attorneys on direct don't say a whole lot, and they let the witness do all the speaking because it brings out their personality. So she's wanting to shut this guy's personality down and try to funnel it. Also because Brennan has a better chance to object, because the more Brennan objects, if this guy's talking about 3 different things that are all under one question, he's looking bad objecting to this witness talking. So he wants to get a front-loaded chance to object by the question. So that's another reason she's trying to help the prosecution here.
Matter.
Because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Next question.
What if you don't have all the details?
Oh, just make it short and
If you
choppy.
don't have details.
Doctor, don't say more than 10 words. That's too much. You may go into some truth area, and we're all about confusing the jury here, and you're talking too much sense and truth here.
If you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you best get details to come to a conclusion in a case?
You need research. You need peer-reviewed articles. You need evidence. You perform testing. You have to demonstrate.
None of that Aperture did. None of it was anything accurate. They had articles from the 70s, one article from the 70s, and they relied on stuff like cadaver tests from them that aren't even considered admissible and reliable today.
What you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from?
That's what Welcher did. He held it out at a 90-degree angle, and you can't bring up what Aperture did. And the judge sustains that this is such a clown
These
show.
two slides.
These two slides are from the
Reversible error every day, hour after hour after hour, reversible error, just absolute corrupt rulings.
PowerPoint presentation that Aperture provided.
All right, so you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that.
Okay, I just want to say, Harry Watson, I'm not complaining about any current British folks following the channel. I'm talking about what happened many 250 years ago. So I think we're all beyond that. And I think we've had a lot of great relations as countries. We're close allies and stuff like that. But there's a lot of stuff our governments do that's wrong, and they create a lot of extra problem for the citizens. So that's what's going on, and more of on a bigger scale as well as a smaller scale, including little areas like Norfolk County, Massachusetts. So I'm not saying anything against you. I don't know why you would think that. So anyway,
for someone the same height as Mr. O'Keefe, the arm would be about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis? The fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter. So we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing the sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but
sorry to cut you off there, doctor, but you know what? Yeah, I do think Julie Nielsen, he was going to make a relevant point about his kids. And you know what? I was just thinking, this is probably the first and only time he can't reference his kids in a courtroom here. No other judge would cut him off like that. even Brennan didn't, I don't think, objected to that. Not that I heard anyway, but shame on both of them if that was the case.
It can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is. Yes. Look at the damage to the clothing. Look, if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis, the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps.
Yeah, that's true, Aunt Nancy. Bev didn't mind Welcher talking about his dad. Oops. And why he talked him into not becoming a doctor and all that personal story stuff. Yeah, that's even a better example than Dr. Wolf talking about making coffee for his wife in the morning. Yeah, he went on quite a bit about that. I was like, how is this relevant? You're trying to win points with the jury, talking about why you didn't become an MD.
Played a part in your.
I mean, even the first witness, Nuttall, he was asked to allowed to explain why he wanted to become a paramedic. So a lot of the personal background of folks came out, and you can't say happy birthday to Kai.
Biomechanical analysis, the methodology that you employ.
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing. You need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry. My question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
That's not going to happen. Not guilty across the board.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report. And the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX57.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
Strike.
So I strike the end.
Would you describe the injuries on Mr. O'Keefe's arm as lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force. They're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis, because
Yeah, that's the thing that's really bothers me too, is that when you stop to think about it, it's one thing if these experts are involved in money fights between companies or individuals and companies. But here you're talking about somebody's life on the line, where they're going to go to prison the rest of their life or not. And so you better do your homework, and you better do it well. So for Welcher to not take seriously that his testimony is going to be argued to try to get Karen Reed convicted and put away, and you just put up this garbage fifth grader, absolute trash. They're not even experiments or science-based things you did, as he explains here. How do you sleep at night when you know that the prosecution is using you to put away somebody behind bars, and you don't even come up with valid scientific-based tests? If you do valid scientific-based tests and you think that really helps show what the truth is, that's one thing. But when you can't even do these kind of tests that he did, and you're willing to come to court and you're being paid, what is it, almost $400,000 or more, that really looks bad, and it's really disgusting.
as you're trying to determine how an injury occurred, you have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step in the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions, and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial.
I'm posting a lot of these birthday wishes to Kai because I do intend to send this to Dr. Rentschler at some point. So that's why I'm putting a lot of these comments up there, because I think it's beneficial to show that, you know what, the judge isn't going to shut the birthday wishes from coming out there.
Abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Cool.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are. Yes.
Did you see, you reviewed the entirety of the medical records as well as the entirety of the medical examiner's file? Is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were.
What could a judge be doing this whole time? She's not, you know what she's doing? I thought about this also. She's sitting there just trying to do everything she can to not pay attention, rustling papers, moving stuff around, drinking stuff. Maybe she's even slurping and stuff. And then you got this guy trying to talk serious stuff to the jury. And then you know what? As soon as Brennan objects, she's right. Sustain. I mean, she's not even paying attention to what's going on, I don't think. And then she's right away sustaining because that's her automatic default.
There were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
Let's keep it clean despite all the corruption.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of three exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or ladies' records?
It was a series of the X-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see? Have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore X-rays, if they existed?
No, if X-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this X-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
Mm-hmm.
You see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma?
Can you imagine? So we already saw the prosecutor hiding so much of the autopsy until near the end of his case in chief. And this is the first time we're seeing x-rays. This is the last witness of the whole trial. On day 31, we're seeing the x-rays. I guess it was the previous witness. So
Bones,
the last
anything associated with those bones?
2 days of the trial.
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the
That just goes to show you they're hiding the ball. They don't want the truth coming out. He doesn't have any injuries consistent with hitting anything like a SUV, not even going 15 miles an hour, not even going 10 miles an hour.
contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie, what are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the, I'm sorry, the bone is the
humerus.
the humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no...
Oh, that's true, Dr. Mr. Monk's understudy, Judson Welcher, talked about the dirt bike riding that ticked his parents off, or words to that effect. So, yeah, I remember hearing something about that. He's just rambling on and on. Thanks for showing how absolutely corrupt this whole process is.
The indication of any type of acute
Yeah, and that would... What's Kai supposed to think about this judge, huh?
injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint.
I don't think Jonah Cost is asking, do I have any idea what the judge is doing and writing every minute of the day? No, it's not normal. Judge should be paying attention, scanning the room, looking at the attorneys, listening intently to see what she needs to object to. I mean, what to rule on for objections. And no, why even pay attention if you don't automatically hear Hank's voice? You're going to automatically, when he's about to do cross and you're having the direct from the defense, you're automatically going to say sustained. So she can just completely be checked out.
Can we go to the next slide, please?
Yeah, I don't know what he was thinking. I don't know how we got these so late in the game. Was it a Brady violation? I don't get it. a Brady violation is exculpatory evidence. Anything in the possession of the prosecution, they're supposed to turn it over to defense. They cannot hide evidence that tends to exculpate or show the innocence or lessen the culpability of a defendant. Otherwise, you can get a dismissal of the charges if it's egregious enough.
See if I can start back in on it here.
Yep, that's true.
Okay, there we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at
He's
the
always
time
writing
of
something down.
this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie
you go.
play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these
Great
series
point.
of photos?
So let's come to sidebar for a minute and Mr. Jackson bring.
Yeah, wouldn't that be nice, Father's Day gift to William Reed with a not guilty on all charges on Friday.
Your PowerPoint, please.
So if you all want to donate to Karen Reed's defense fund, you can Google that. It'll pop up. I guess for people out of the country, you can't do that if you're outside the United States. But I believe they have a link to things like Venmo. Yeah, that'd be nice. Say happy birthday, Kai. Yep, can't mention dog or garage. Trying to jump ahead here. He's doing too good. Judge doesn't like this.
Sure.
Yeah, if you have questions, red emojis helps me see them. Distinguish them from regular comments. Chatter among y'all. Yeah.
One moment.
Okay.
Dr. Rentschler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this? That's
Number
on-
12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please?
Yeah, Lulu, I don't think they're going to be worrying about some other case. I think they all realize that this is involved in the same trial. And I think a lot of them have already researched it and are following this on a daily basis.
Did you also look at and consider these photographs in coming to your ultimate?
I think most of the jurors know that the FBI is who hired ARCA. They're making such a big deal about it and talking around it. We heard Jen McCabe mention the FBI came to her house. If they can't put 2 and 2 together from what they've heard in court, they're probably checking it out online.
A conclusion.
And there's also signs, I guess, all over town saying the FBI hired ARCA as well.
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions
I
regarding
did.
this case?
Yes, sir.
Yep.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yep. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the
All that. Gene Lee, yeah, I was thinking that too. Welcher might have been the one saying, "I'm not coming back there. This guy made a fool out of me." I was thinking the same thing today. Took the 4K and bolted.
yellow
I wonder if that's what really happened.
indicators?
Those are indicators I added based on the length.
I'm tending to think he said, "I'm not coming back." What's he going to refute with this guy's numbers, his math, his science, all that? There's nothing to refute. You know how much time it would take for him to do testing and all that to try to refute this guy? So you can't refute it. It's irrefutable.
Of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many
The only one who said there was a collision and was Welcher. That's the only one.
injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact with to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Can you scroll to slide 22 quickly, please?
Yeah, that's true. The x-rays.
What is
Yeah, the x-rays too. Yeah. Trying to explain that. Looked like yeah, maybe Hank told me we can't bring you up here because we hid the x-ray slides. I mean, there's no way he could have called him in rebuttal. I was wondering that. What's there to rebut on this guy? You got nothing on him. Welcher would have to start all over. He's not going to start all over.
What is this?
This is
And if he did it by the book, he would be supporting everything this doctor says.
a slide, again, from Aperture, from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret
sure.
that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the tail light, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from Aperture?
These are all from Aperture. I did not put any of those on there.
You see the small, it's horizontal, I'm sorry, it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the Aperture report a denotation of the number of abrasions counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or.
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yeah, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time.
With the 9 holes in the right sleeve?
With the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure.
Shannon, I think that better be highlighted big time in the closing argument. So they should remember this, all the tricks and stunts the
Let's go to the next
prosecution
slide, please.
pulled.
What is this?
These are the top 2 and bottom right slide are from the Aperture PowerPoint.
How did you interpret the 2 photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured taillight, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keefe's upper arm, and there's a red arrow pointing to part of the fractured taillight.
Can we go to the next slide, please? What are we looking at in this slide?
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the taillight and the arm in this case and the interaction between the 2.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Yeah, he calls him out for falling into the car. This is not a scientific test. It was a stunt.
Important?
It's very important.
Why?
Because you can't say that the area where the blue paint is
He fell into the car.
corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. you can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher, as it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear taillight of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the aperture data?
I did, yes, sir.
What were you seeking to determine?
Yeah, I was hoping that he was going to blurt out at some point the Bureau or FBI. Well, we're going to get to that on this absolutely
When you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle.
Yeah, one test at 1.9 miles an hour with a human test dummy that's falling into the car to try to get more paint on the upper part of the arm.
Or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide,
Look at that.
the picture on the
That's unreal. I'd keep objecting. I would be objecting so much if I was on a case like this and judge pulling these stunts.
cover.
Can we go to slide 25?
Look at this.
What are we looking at in this slide?
So in this
What the heck is
slide,
he doing all the time?
picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle's actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please?
Yeah, so the ones above the elbow would be horizontal, and then the ones along the arm, or the forearm part of the arm, those would all be the length of the forearm. They wouldn't all line up perfectly as
This
horizontal.
is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in
What a
order for the
joke.
paint in this test to reach the upper forearm?
Oh yeah.
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up.
Yeah,
with the
you wouldn't
type
have
of
that upward.
kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. O'Keefe's arm if in fact it contacted the taillight and if in fact it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same. Well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types
see
of
that.
measurements whatsoever.
Can we go to the next slide, please? This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down. And so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please?
It's not a
Did you
science
see what
test.
you were describing in that video?
I did, and I can.
You need to see something real life in action to support the government theory. The government theory was not 1.9 miles an hour. This is going to make John O'Keefe fall backwards and hit his head on grass.
And slow it down. So you can see
Get that massive brain damage that kills him? I don't think so.
even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow. All of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and
Yeah, he's all over the map. Brennan is.
contacted their arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the
It's
next
not a
slide,
part of
please.
scientific testing. He's an expert in this scientific testing that should be done to explain or to demonstrate what most likely could have occurred under any theory to show how John O'Keefe either was hit by a car or wasn't hit by a car. And you can't bring out the fact that this wasn't even scientific. That's a cover-up right there. That's a cover-up.
What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Thank you. Can we move to the next slide, please? This is slide 30. And let's go to 31.
Yes, that's what I've been saying. All this stuff about the phone, the black box, and all that. There's so many variables in all that computerized stuff. It's not meant to be forensically used to really be that reliable to convict somebody. You're going to base a conviction on that. So I think right here we're proving it. This is more science-based stuff, not on some faulty electronic stuff. Any of those kind of location things have huge margins of error in them.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of the arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The
for those
basis
opinions?
is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33. I may have just a moment, Your Honor.
Yes.
Yeah, I was thinking the same thing because I didn't know it was lacerations. They're talking about fat and muscle, though, but don't know for sure why they would say that.
Did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt with 9 holes in it.
That's sustained. You have to ask that differently, Mr. Jackson.
Shorten it up.
Did you determine, based on the testing by aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint test in which the arm was leaned into the car?
In which the elbow was shot forward and then
Yeah.
the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need.
The points he made about the angles of the abrasions / lacerations says it all. I mean, that you can't argue with that. That's just common sense. And that's why I'm thinking anybody on the prosecution side pursuing this, they all have to realize that that's like the massive Achilles heel for their whole theory, is that those arm injuries are not from any vehicle at all. It's just whacked out crazy talk.
Need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies. They use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often.
Wow.
So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar. So if your hand was hit by the back of the arm was hit by the back of the car and propelled forward, that's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm. And here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm, And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we go to the next slide, please? And what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, the acceleration here is almost 300 Gs.
What does that mean
So
just to
That's
us?
a lot.
So 300 Gs. If you look at weight, if you say the weight of the arm is 10 pounds, 300 Gs means there's 3,000 pounds of force
Wow.
acting on that arm.
Yeah.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
I've had a ladder, one of those extendable ladders, fall on my foot with shoes on, and it broke one of my bones in my foot. So you're telling me 3,000 pounds isn't going to break something in your hand or wrist?
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Yeah, that's breaking.
Is the arm accelerated in this? Do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide, please? What is this showing?
Guys, know this.
So this is a slow-mo of the overhead from the real time. It was a GoPro that was recording that real-time video. And this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being contacted in those milliseconds where it's being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24 mile an hour impact?
G-force, let me see exactly.
Could you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
That's planned
Do you
delivery
need to refer to
Friday.
something?
Yes, my report.
after
With the court's
instruction.
permission?
Yes.
Thank you.
All right, I think I'm going to jump ahead here.
So at 24 miles an hour for the arm,
Or
the acceleration is 302 Gs. And for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back. Right there. What's happening physically to the arm, to the right arm at the point of impact?
So there is a force on the hand, on the forearm, where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm
that's going
is
to help
actually
break it.
articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, certainly there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
Correct, nothing.
all right, I'm going to go ahead, jump ahead. He's got some other good slides. but I want to get to the, just for time's sake, I want to be able to cover all the cross tonight without getting too late. So let's go to 304. This is a really amazing stuff here.
Please be seated.
Dr. Rentschler, facts matter, don't they?
They do, yes, sir.
You said it
Just the way he said it, facts matter. He sounded nasty already.
many times. Facts matter. Isn't that correct?
You could have just said that one time yourself.
I think it was details, but facts matter too.
Do details matter, doctor?
They do.
Listen to that smart aleck tone. Just nasty tone is not going to get you anywhere, Brennan. He doesn't even understand that.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you
Yeah.
think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is
He's not counting for the angle also.
from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm
Yes.
asking you, not nobody.
Yeah.
Listen to that. Nobody does. Not even Welcher said that. This guy's pushing back. He's not taking these gaslighting efforts.
At least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me,
So go ahead and ask the
You-
question.
Dr. Rentschler, before this jury, have no idea.
Look at how emphatic is no idea. Well, then why don't you tell us where it is, Brennan? What are you going to make it up this time?
Where the point of impact was of this collision, do you?
that's correct. There's no evidence.
No evidence of a collision, so there's no point of impact. So you can't say where it happened if it never happened.
Play exhibit 2, please. When you were giving your estimate 10 to 20 feet, Dr. Rentschler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before.
Yes.
And when you looked at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure. Yes.
Sure.
Yes.
20 feet, Dr. Rentschler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do. Yes,
You
sir.
take that down, please.
Yeah, you said it 3 times now, Brennan. You're just coming across terrible here. Very much like a
Did
bully.
you speak to anybody today before you testify about Dr.
Sorry, they already know about your antics to make it look like there's some secret drug deal going on. If the lawyers happen to talk to their expert before he testifies.
Welcher's testimony in court?
I did not today. No, sir.
Before today, did you speak to anybody about Dr. Welcher's testimony?
I did not. No, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so. No, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did. Yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the
He hadn't finished his credentials yet? Really? Okay, well, they didn't ask about his education a little bit till later. I don't know which one was first, but you seem to have you're blaming this witness based on what the prosecution is asking. That's a real sleazy thing to do. The order of questioning is dictated by the attorney that calls you, not the witness. And you know that, but he's trying to make it look like this guy is selecting what to ask him of Jackson.
Testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy
Oh,
represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
it's all smoke and mirrors. It's all confusion bombs. That's what defense attorneys do. I call it confusion bombs. You just try to confuse everything, confuse witnesses, just drag stuff out, make them not remember what they said, ask them questions that that you know they can't answer to or won't answer well to. That's the kind of stuff defense attorneys can do to rattle witnesses, and that's all he's doing here is just throwing stuff up against the wall, trying to pull him into his nasty mud pit. But these guys are all class, professional, super highly qualified experts. Just doctor after doctor after doctor is just crushing the government's case. They've proven beyond any reasonable doubt. In fact, they've proven beyond a reasonable doubt that Karen Reed is not guilty.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio, force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Oh, not that again.
Prior?
Yes.
Yeah, I didn't discuss at the case.
This is how underhanded this guy is. He's trying to bring up the sequestration order because he's trying to imply that this guy is breaking rules when it's the FBI talking to him. And they're the ones that hired ARCA. The FBI is not bound by this judge's sequestration order. So anyway, the charging
Case with anyone,
conference
no.
where they haggle through what the jury instructions will be. I've already talked about the jury instructions 2 nights ago. If you guys want to look at that, there's some stuff I brought up about how they're trying to talk about how Karen was interfering with witnesses. That's what the government's asking for on an instruction. And they conclude that there's an inference you conclude she was guilty because she's interfering with witnesses. It was like, what witnesses harassing and intimidating stuff like that was ever brought out in this trial here? There is none. So I don't think they're going to succeed in getting that instruction.
Well, you didn't discuss it with anybody, you said?
I did not know.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Objection, Your Honor.
It's not employer. It's the contractor.
Maybe we can approach briefly.
The party to the contract, which is the FBI. Not your employer, ARCA. Again, this whole thing about the FBI is just so misleading. So that's what I think is so dirty and corrupt about this process, is that it's bad enough they can't bring up the FBI hired them, but then to try to use that as a weapon against ARCA, to try to say that they're acting shady behind the scenes and violating a court order, that automatically should bring it in. You cannot impugn criminality and misconduct and deception and trickery and deceit and all this kind of stuff that he's trying to do to an ARCA witness when they're doing what they're contracted to do with the FBI. So, and they were never a witness until they were released to actually testify. And that was only right before the first trial. So to insert all this kind of stuff by Brennan is so underhanded. And only this kind of judge would allow it.
Before you testified last year, you were receiving information, not from the defense, from your employer.
He should not be allowed to go into any of this. The judge is absolutely way outside of her lane by shutting this down. Morrissey doesn't want this coming out. Yeah, I hope the Bureau goes after all these people that are responsible for trampling on the Constitution.
About other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Like the FBI is going to be leaking stuff to get him to change his expert opinion on stuff. I don't think so. So if the jury knew that this is the FBI, do you think he'd be asking these questions? No, the only reason he's asking these questions is because he's trying to hoodwink and bamboozle the jury into thinking something dirty's going on with this guy. So that is dirty per se by the prosecutor.
Voir 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It did.
He already said he goes over and over the same stuff like he's going to get somewhere with it. And this guy doesn't flinch at all.
Didn't make a difference to my analysis or conclusions.
Made no difference.
And you know what? He knows that. Brennan knows that doesn't affect his tests and all that kind of stuff. It's just nothing but trying to rattle this guy and be I got to watch my words, but you guys get what I'm saying.
Difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all. No, it doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
That's so, oh my gosh. I was so mad today when I was hearing this going on. I was like going, blurt FBI out, blurt FBI out. What's it going to cost you? What are they going to do? They're not going to strike his testimony or anything like that. I guess maybe they would, but because that wouldn't be a real court of law to do that. But nothing about this is due process required by the Constitution.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to
I wish you'd at least say the special agents.
or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question, and I want you to give me a very specific
Objection,
So just go ahead and ask the question.
Are you denying?
Yeah. If they blurt that out, it's not a mistrial that's declared. There's not a mistrial that they start over because of something the defense does wrong.
That receiving that information certainly helped you prepare?
You know what? They could say asked and answered. I'm sorry. They could object and say asked and answered, but they're not allowed to say why they're objecting. But the judge is just going to allow this badgering of this witness to go on unless he has for so many witnesses day after day after day. That's what's so hard to.
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter, so let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? You denying it?
objection.
First of all, he could look at the entire transcripts if he wanted to. There's nothing that stops him from looking at stuff that came out at another hearing about this matter. He could look at other expert testimony. So it's just all trickery and deception going on
I'm
here.
going to allow it.
Yeah,
And she
I don't
allows
think
it,
that
yeah.
it did. It's been a year, but certainly
Evil.
it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question.
You know what? He's just doing nothing but trying to tick him off because he wants to pull him in his mud pit. And this guy is so smart. He's not going to get up there and start yelling at him. But some of y'all have asked, it's like, can't you just turn to the judge and say, are you going to let him treat me this way? Is this a real court of law? Say something like that to put it on the judge.
Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
Objection.
I'm going to allow that.
I don't even think that it did. I don't understand that.
Well, I can't even. If this was going on in any other case, I would shut this channel down. I would never cover any case again. If I saw this kind of evil, corrupt crap going on, I couldn't take it.
I understood what was happening. I understood what the theory was.
You guys are
So saying that there's trace DNA
You know
doesn't
what?
change anything.
The jury's going to have the final say Friday. They're going to expose all you clowns.
Doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had
It's already
phone
destroyed.
conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualifications, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mhm. Was there any discussion on how you could portray yourself
Still moving around,
as
flipping stuff.
independent?
I don't believe there was.
So you don't believe.
Yeah, there was no need to.
That's not the question. Details matter.
Details matter. That's 4 times now, Brennan. You are the worst attorney in a court of law I've ever seen.
Was there any attempt?
So the objection sustained. I'm going to strike that, folks. Okay. Questions, Mr. Brennan?
Was there any attempt in your conversations
Bully
to
Brennan.
portray
Made him, yep.
yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
And did you tell the defense that you prefer to take an Uber so that it would appear independent?
That's what this comes down to. You're trying to impeach on whether he took an Uber or not. That's going to show whether he's independent or not. They're hired by the defense this trial. The defense is paying for him, not the FBI. You know automatically that's how it works with experts, but he's trying to trick the jury into thinking there's something shady going on here. So that is
And then to a jury?
so unreal.
No, because I didn't
gotta
take
watch
an
my
Uber.
mouth
I took
here.
their ride. If I wanted to appear independent, then I would have taken an Uber.
You have a conversation about that you were thinking about taking an Uber.
If you merely had a conversation about Uber, really, that's what we're wasting the jury's time on. That's all you got. Thank you, Brendan, for showing us how little you got to cross-examine this guy on.
It didn't even cross my mind, sir.
And then after you
sorry.
testified, did you stay independent?
What do you mean independent?
Well, did you have any bias for him in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
Had a ham sandwich. Did you testify?
Oh, that's something he's going to try to mock and ridicule him on. You know it because he repeated ham sandwich.
At some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
What do you think Welcher was doing? He's hanging out with you on Sunday, Monday, doing all kinds of stuff with you multiple days, Brennan. So it's just unreal. No honor as an attorney doing this kind of stuff. That's why I call the jury the equalizer. Equalize and override this corruption here.
When you sat at the table and eat, did you just eat your ham sandwich or did more go on?
I ate. People were talking.
What kind of bread did you have? Did you put any mayo on there? What about any mustard? Did you use spicy mustard or was it Dijon? Or was it just regular mustard? What about a pickle? Did you have a pickle on there?
really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk
Oh my gosh, if you laughed, you're biased. Oh my gosh, you're biased. I can't
about
believe
the
this.
testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and your answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. What?
You're not allowed to talk to defense attorneys. You're not allowed to talk to your client that hired you to testify because you're dirty, you're corrupt. You know what it is? It's all projection because you know what? He's doing all this talking behind the scenes. You're the one, Brennan, that called up Burgess and got him to change the report in the middle of the trial. So all this is projection. If he accuses somebody of doing something, he's doing it himself. And this is nothing wrong about what he's done talking to the defense team. They're the ones that hired him. You need to talk. You need to prep. You need to know what questions to ask. As a lawyer, if I hire an expert, I don't know all the questions to ask of all the tests being done. I need to have him tell me What are the best questions I need to ask you to help you explain what your expertise is trying to project to the jury, to convey to the jury?
Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Do you know what a conversation is, you idiot? Hey, you over here, idiot. Do you know what a conversation is? Do I have to pull out a Webster's for you? Over here.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week.
Where were they seated? Where were you seated? Were you on the end of the table? And who was across from you? What did they look like? What were they wearing? Who was on your left? Who was diagonal across the table from you?
Let alone a year ago. So I probably did, but I have no clue
Do you remember any,
what we would have talked about.
do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response. Well,
What if you would have said, yeah, everybody there is talking about how corrupt you are. That's probably what they're talking about. And you're going to be grilled on the stand over and over again of the fact that we're having lunch together. That would have been a good answer. Oh yeah, somebody else actually just said that. Anyway,
physics.
obviously he's been bullied. This is a revenge of the bully. He's been bullied and now he became a bully.
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there?
Boy, still going
How
on.
long do you think?
This is actually, I just got to laugh at this. If you keep on asking this over and over again, and then you have to bring up the ham sandwich, you look like, yeah.
That went on for.
I honestly don't know. 10 minutes. How long does it take you to eat a ham sandwich? 10 minutes?
Well, you should know that, doctor. Why can't you tell us how long it took to eat your ham sandwich? What time did you get there? How long did it take for you to get to your chair? I mean, you could just go on and on with these little details, and he thinks he's scoring points with the jury. Yeah, I agree with you, K. Reggie. This is the dumbest questions well, he's had so many of these dumbest questions you ever heard. Yeah, this is.
And after you finished.
I don't know. I don't know how anybody would ever. Anyway, I'm not going to say that.
Your ham sandwich, and then you told us you stood in the corner. You got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport.
Oh, so you got a free ride, I bet. I bet you didn't have to pay for the gas money, did you? They were bribing you, weren't they, Dr. Rentschler? You took a bribe.
Ultimately, your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Yeah. Can you realize what a joke this court is? If I was a judge, you think I'd let some attorney make a fool out of me and I'm not going to control this browbeating, asinine garbage going on? And this is a spectacle. And then you're just going to sit up there looking around, fumbling around with paperwork. It's just, I can't believe this.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
Oh my gosh, it must have been a $12 sandwich. That impacted and corrupted your report. And that's in fact impacting your testimony here today, isn't it?
And then I'll get a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much has ARCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case. You have no idea.
You're telling me you never checked to see if you got reimbursed for that ham sandwich?
Yeah, it's not my concern. It's not my department, so I don't.
That's a no?
That's the no, sir.
Now, when you communicated with the
Even
defense,
that's a no is a really bully garbage maneuver here.
you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with, yes, with whatever I had.
Did you
Yes.
have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day,
And I thank the defense for paying for my ham sandwich. Oops, and I had to erase that, right? Because this was going to come out in court that you reimbursed me or paid for my $12 ham sandwich.
like I do many times, I'd probably erase those texts.
Because I knew I was guilty. I knew I was busted. I knew you would have proof that I was corrupted and biased.
Say probably, did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
This
I'm
is
gonna
so.
allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use?
You can secretly find out where to get the best ham sandwich deals near Denham.
Use Signal to have conversations with their clients?
I'm going to allow that you're aware.
I have no idea what my fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah,
Yeah.
you worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
She would never allow this to go into what kind of app you used, messaging, text service you're using, and it's encrypted. The FBI tells attorneys to use this type of encryption. They even mention Signal. There's a message that was put out by the FBI and CISA, Computer Security Agency, and they are saying use apps like Signal if you want to keep your stuff protected. So this is somehow twisted into a nefarious, sinister, evil plot. So keep in mind the projection going on here.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that?
Yeah, all cabinet level folks even use it in the government. I didn't know the government created Signal. Interesting. I thought it was foreign owned, like in Sweden or something like that. That's what I thought John had told me. Or maybe I'm thinking of Telegram. Maybe I'm thinking of Telegram.
Objection.
Sustained.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have,
Yeah, can you imagine if you had had a steak dinner, went to a steakhouse? My gosh, that would have really exposed him in the arc of corruption.
free reign to do whatever he wanted?
Objection.
Sustained.
Free reign. You could do anything corrupt you wanted, right?
Were you given free reign to do whatever testing you wanted?
Spend whatever money you wanted.
I don't believe we were, no.
You, though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
Objection.
So without that preamp, go ahead and just ask the question, please.
Did you suggest doing crash
Did
tests last year?
Did you?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
You're
Do
lying.
you, since your memory is difficult,
Objection.
Sustained.
Your memory's difficult because you're trying to lie. I mean, this guy's just
Okay.
what a joke. What an absolute joke. I mean, this is is this a real trial, guys? I cannot believe this is actually a real trial I'm watching. I only got to think of the verdict. That's the only thing that's allowing me to keep some sanity here. Is that he's looking like a fool and he's not going to win. An evil fool is not going to win here.
to remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it
I mean, what kind of a dumb question is that? Really? You write stuff down. So in other words, you got secrets you're writing down. You're trying to pass them to the defense, aren't you?
is.
Look at the person up there that's supposed to be a judge, supposed to control abuse of and tyranny in a courtroom. Don't you realize that you're actually helping get an acquittal by allowing this chaos to go on in the so-called court? Yeah, maybe she's never done trials as a defense attorney, so she doesn't know what a jury actually thinks.
You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education.
Yes, sir.
Did you falsify anything like Burgess did?
areas of specialty.
Correct.
And then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications.
Yeah, I did see the judge doing like this, and then she put her hand away. You could tell she's trying to finish up talking, and she looked guilty, and then try to sit up and act like nothing's going on. Yeah, I guess with an Apple Watch, I was in her wrist. If anybody wants to send me that, I'll play that at the end tonight. Because I think there's something there. I think she's talking to somebody.
Mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school. Correct.
Have you had any peer review articles since 2003?
He just said it. He hasn't done it since 2004. He did it when he was working on his graduate degree. He hasn't done it since.
Probably not, no.
And your peer review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yeah, the fact they want to add Karen to what is bullying witness or whatever they're saying shows they do not care that they are trying to put an innocent woman away for life. Despicable joke that came out. Well, they actually, defense should ask for a jury instruction on all the bullying going on is an inference that she's not guilty. So just twist it around. What the prosecution is asking to have instructed to the jury, I'd use those same words and substitute that for Brennan. Instead of Karen Reed, I'd put Hank Brennan trying to intimidate witnesses and browbeat witnesses. That kind of thing is an indicator that the Commonwealth doesn't have a case.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test.
Well, you just don't have this kind of. I gotta watch my tongue. You don't have this kind of behavior, let's call it, in a court of law because a judge would not condone it because it's actually disrespecting the court. So this court has no self-respect because no self-respecting judge would let a punk like this talk to any witnesses like this and do all these kind of tricks and stunts he's been pulling. So this is abusive and it violates due process. But if you don't have a judge that has her own self-respect to stop this stuff, she's encouraging it because she keeps allowing him to do it. She's never once put him in his place. Even if she grants something for the defense because of some abusive tactic or stunt he's pulled, she never scolds the prosecutor, never once.
Dummy to accommodate higher mass.
Unbelievable.
Yes, sir.
And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
So he's just humanizing himself even more by having to talk about all these things that he's worked on to help real people overcome real disabilities and hardships in life. And that's what you're going to try to beat him up on? Wow, are you clueless?
No, they don't.
You've written a book chapter.
Yes, sir.
smart technology for aging?
Yes, sir.
And again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts,
Yeah, so even this shutting down the birthday shout out to his son Kai, that automatically put him in a sympathetic, likable mode that lasts throughout this trial. So even the judge can't pick up on how she's actually helping the defense with their witnesses. So these defense witnesses are also likable, except for obviously the Boston cop, Dever. But so what's going on here is that what I pick up on when I'm doing jury trials, I believe that they want to cheer for somebody, just like watching a movie. I consider myself like a movie director when I'm doing a trial. And so I got to bring out all the personalities and humanity and pull on the heartstrings of the jury by making the case come alive and bring out the really neat things about the different witnesses that they can share. And so by her shutting him down with his birthday shout out, it's like you're just wanting this even more, the jury to vote in support of the defense.
you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with
So, yeah. Oh, you're doing working on wheelchairs. Like, oh, okay. So that doesn't have anything to do with SUVs sitting in the back of a police officer, right?
pedestrian collisions.
I don't believe so, no.
Looking at your CV, you
Great job, Hank. You're just really making this guy really likable. The area is helping soldiers survive MRAP IED explosions that are killing them, and those that survive are severely paralyzed. And now you're helping other people in wheelchairs. Maybe some of this is also soldiers that that have serious disabilities from IED attacks in Iraq and Afghanistan. But no, you're not a good guy. You'd go do something shady and corrupt for a $12 ham sandwich.
can note any area of specialty you'd like. Correct?
You can put down whatever you like, I suppose, sure.
Sure. Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at times, didn't you?
To some extent, yes.
Didn't you? How dare you? How dare you do that?
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if
863 Gs. That's a massive amount of force.
something was different or off, would you correct it?
I'd talk to him about it, sure.
Okay.
Now, this guy's a dirtbag, trying to help out people in wheelchairs get around better. Nah, he's no good.
Did you ever talk to him about his collection of data?
Ain't going to make him out to be exposed for what he really is, some kind of grifter for $12.
Regarding peak acceleration that the arm and hand experienced at a 29-mile-per-hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welch, right?
Sustained in that.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
I
Did you
can't
try to
hear.
interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray as diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report? Or were you doing a certain
Regurgitating right there. That's a demeaning term.
kind of,
Sustained.
were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed?
He almost interrupts the judge. He's just like going to keep on going, badgering this guy.
Didn't show.
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion or are you regurgitating what you read in a report?
There you go again, regurgitating. That's disrespecting a guy with a PhD in this field. He's been doing it for 20 some years. Are you going to talk down on that way? Wow. If this jury is longer out than Friday, then I gotta do some serious rethinking about where juries are headed in the next decade and beyond.
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
3 times now regurgitating. He just said what he does with it.
Sustained in that.
No, it should be, you will not talk to this witness this way. You hear that, Mr. Brennan? One more time. You know, threaten the judge. The judge should be doing some kind of warning like that. But you know what? This isn't a court of law. It's a court of lawlessness and persecution.
See any MRIs?
I don't believe any MRIs were taken or performed.
In x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an X-ray. Yes?
Sometimes X-rays are the best for looking at bony fractures. MRI is looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit
Oh, this is such a dumb
or struck
question.
by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That's always happens that way, doesn't it? Because not everybody's hit the same way. Some people survive and other people die in the same vehicle.
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible.
I mean, from my experience, you act this way. Well, first of all, a judge would never allow it in a real court of law, right? But the fact he's getting away with this, if this jury doesn't come back Friday afternoon, then they're complicit.
Asking your experience. Have you
I'm going to allow that.
ever been involved
I'm going to allow this. I'm going to allow that. I'm going to allow this.
crash where there are multiple
In a real court, you'd say overruled and sustained when there's objections.
pedestrians hit by one vehicle and they sustain different or in some cases no injuries? That ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Imagine if you just came up to the back of that SUV, let's just say an exemplar one, and you took your hand and just bashed it up there as hard as you could. You probably wouldn't even break the acrylic. So imagine if you took your arm and bashed it hard enough to bust that acrylic out in 47 pieces. Do you realize how badly your arm would be damaged? So set aside the vehicle moving that fast. This is use your own strength to try to hit up against that acrylic corner of the tail light, and you're going to definitely have bruises. And if it's something you go 24, 25 miles an hour, you're talking about way more damage than that.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries. Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries, and another case where you look at where there is a similar type of collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
Do you mean hit the same way
Nothing to do
with the
with
same
anything.
type of car at the same speed with the same force?
I'm
Just
going to allow it. Can you
Rambling
answer?
gibberish.
I don't believe I've ever
Have a
seen a
point.
case where two people.
Cross-examination is supposed to have a point. There is no point to any of this. It's not relevant. There's nothing you can do to discredit this witness based on bringing up the fact that different people have different injuries if they're all in massive different car accidents.
People were hit with the same car at the same speed, with the same force, with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters? Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that.
Well, of course they're going to break up different because they're going different speeds. Hello?
Is that funny?
It's not funny.
Okay.
So
Oh, wow. Okay. Okay, this is like,
When you looked at all the tests you did,
you're going to treat a PhD that's missing his child's birthday, his 10-year-old birthday party, and be treated like scum? Really? And this guy's laughing? You think he's laughing, having sit through all this garbage you're throwing at him?
plastic broke differently in each and every case, every experiment, didn't it?
Because you asked.
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that. Is that funny?
Oh man. He did. That's the question he asked. And he's answering it. So
Personal
let's go.
experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that.
Oh, he's trying to focus back on this case instead of some whacked out hypothetical nonsense that you're talking about,
Is
Brennan.
that funny?
It's not funny.
Okay.
Yeah, it's not funny. You're an absolute joke, and you're not funny, Brennan.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more.
Yeah, she can't control the courtroom. There's no control there. It's a free for all for for the bully.
Comments.
When you did your experiments, the
Sick.
sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
He doesn't get it.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count?
Did you watch the videos? Did you see the plastic break off the tail light? I mean, he's talking to him like this is
How many pieces broke?
like he's some stupid little kid being scolded. This is how he talks to his kids when they get his son when he gets busted for doing something.
In each experiment?
I didn't specifically count. No, we looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not. No, sir.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please? Were you ever under the impression that Dr.
See, even that comment, you've been talking quite a bit about the paint and Dr. Welcher. See, that's a narrative comment that defense is told to quit commenting on your before your question, but he gets away with that kind of stuff all the time.
Welcher was trying to reenact the actual collision when he did that blue test?
Okay, I didn't catch the first part of that.
Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
Can you believe it? Now he's trying to say that wasn't trying to recreate what happened to John O'Keefe. I mean, you talk about gaslighting and misdirecting here.
I'm going to allow it.
Yeah,
Well,
wow,
that
this
was
is
the
good.
only test he performed, and he
Yeah,
referenced that test for his opinion that
Brennan is so over his head. He doesn't know what he's doing. He's actually bearing his own case by asking these questions. So keep it up. Keep it up.
position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to
If it's not trying to recreate what happened to John O'Keefe, then you're trying to mislead the jury. You're trying to trick the jury into thinking that wasn't what must have happened, but you're not saying that. You're not trying to actually say that's what you're trying to project for the jury to understand. So either way, it's deception.
signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm
Right.
in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusion.
Awesome answer. Awesome answer. And this is complete the kind of shady stuff prosecutors are never supposed to do.
Now that you've shared your opinions, can I get back to my question?
Sustain.
Wow. That
Of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and
yeah, way worse than meaningless. It's absolute corrupt.
conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
Yeah. Oh, it's sidebar. She never says, you know what? Knock it off, Brennan. You will not badger and demean this witness this way. Anyway, it's just unbelievable. Unbelievable. They can't get a real judge to try a murder case in Massachusetts. Shame on y'all. All right, I got to calm down. I'm going to be scaring Leo here.
take an hour.
All rise for the court, please.
Yeah. And you guys wonder why attorneys have a bad name. And judges now included. Okay, let me check the time here. So they have an over-hour lunch break. So let's go to 5:04.
Be comfortable enough in here this afternoon. The court office is.
I wonder if he's going to ask him if he had another ham sandwich with the defense.
Has done a great job keeping the AC going while we were out of the courtroom. So.
Dr. Rentschler, you wrote a report back in February 2024,
That's correct. Yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did. Yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct. Yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes. Soft tissue referring to ligaments and tendons of the elbow and shoulder. Correct. And the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes. When you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at or that we saw and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of. No, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself. No, sir.
Yeah, if the guy's not taking any notes at all, that's a real bad sign that they just don't really care. And if you don't have somebody that cares, that could be a plant.
A crash test dummy is different than a person, isn't it?
Certainly it is. Yes.
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
No, it doesn't cry, Mr. Brennan. It doesn't bleed. It doesn't cry. You don't rush it to the ER.
Well, it does to a certain extent. Yes.
You don't have to rely on Jen McCabe calling 911 to make sure the ambulance shows up and the fire paramedics.
There are differences.
Certainly there are. Yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did. Yes.
And in his report, there were a number of references, weren't there?
There were different references, I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of
When
information.
you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Listen, that's the judge.
Well, I was referring to, there's only one reference.
That's the judge making all that racket. Listen to that. You can actually hear it. It's picking up on her mic.
For most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references,
You
did you
read.
look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that
I would just say, if I was the doctor, I'd say, I can't hear with all this noise coming from here.
there was only one reference, you were referring to the
Smell
paint
that.
test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian.
Oh man, she's never done that when a government witness is testifying.
and impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
We're going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The
Yes.
question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yeah, certainly other articles in the 60s, 70s, and 80s, he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
I think there were, let's see. Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve, as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not
So you're trying to impeach Welcher for being a crash test dummy, a real live human crash test dummy?
there would be documented damage to someone's skin
No, it didn't. And that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not. No, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its relation to lacerations, severity, indices. You know that, you cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Postmortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right. To look specifically at laminated glass and it's the cuttability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct. And that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies
My question was, see, right there, just demeaning,
Appropriate.
abusive.
for analyzing skin lacerations on a collision, does it?
Sure. I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit.
Of course he was. Why else was he doing that?
Do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, If he didn't intend to do that, then there's no evidence.
He actually testified, and it was brought up where he said that Karen's SUV did hit John O'Keefe, and he was demonstrating it and using the video clip of the Blue Man science, so quote unquote science experiment. So because it wasn't his report, but he testified to it. So now what Brennan's doing is he's splitting hairs and he's trying to make it look like, oh, he never said that was actually what happened is what I was demonstrating. I'm not saying that's what happened. I was just showing what an example of what could happen or something like that. I mean, this is so deceptive. It's unbelievable.
That he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover.
That's right. The only test. So why else would he be doing it, Brennan? This is so misleading. Unbelievable.
If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Why didn't you just lay on the ground and have the car run over him? Would that help show what happened to John O'Keefe? Maybe the tires hit him in the head, caused that crushed skull.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
What a spin. Wow, what a spin move. This is so slick.
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended.
You know, defense should have done a move to strike his entire testimony then, because he's completely misleading the jury. He's doing tests that were not representative of what the prosecution's theory is.
To do. It seems he's inferred that. And again, that's the only test that he's performed or referred to.
Remember, he said exactly matched up. He showed the arm there and he says it exactly matched up. What else does he talk about? Man, what
this case?
You inferred that.
Inferred that that's how.
Man, so now we got the issue with the x-rays, the hoodie holes, and now this, that the Blue Man demo, he's trying to backtrack that and not make it look like that's what we're trying to say happened to the jury. So in other words, you're trying to trick the jury by showing something that didn't happen, really?
That's how he believes that the arm was positioned.
I think we understand your perspective is that's the only test he performed. But what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welch ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture.
Yeah, he's ticked off because, you know, you're lying to this jury. You're lying to this jury. No, prosecution goes second. Defense argues first, and then with their closing, and then prosecution, there is no rebuttal.
Of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except
he knew the Blue Man is a ridicule, a laughing stock, non-scientific experiment. Hank knows that, and now he's trying to walk it back by saying, well, he never actually says that in this report, and now he's trying to get this guy to say that this was something other than that. It has to be something other than that. What else would it be? There's nothing else, but he was trying to demonstrate because he had the arm perfectly aligned. That's what he was trying to say, that the arm was perfectly aligned with the scratches.
Except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose. But if it's not, again, then I'm not sure what that test actually accomplished or represented.
You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
Yeah, so there's zero evidence presented by Welcher of how the arm got struck or had those injuries.
I'm going to try to make my question a little clearer.
Unbelievable.
Is there anything in the report where Dr. Welcher has stated
Never.
that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Rentschler, anything that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
He never gives any details. He just went up there, showed this is how he was hit. And he actually said that the vehicle struck John's. He said that at least twice that I caught. The defense didn't object. And then he had to change it to say the consistent, the injuries are consistent with being struck by a Lexus vehicle like the defendant had, or words to that effect. So that was definitely something that he's trying to walk back now. And it's a complete misdirection, 100% misdirection now.
I don't know whether Dr. Welcher has been clear that he does not know. Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed,
I'll let him
you don't
finish.
know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that actually occurred. That's the basis. Yeah.
So
If you don't have the
You
information, you can't replicate what happened. You can't determine.
He just killed his case right here. Welcher cannot even say where he was at, what speed the SUV was going. No details. None. They don't even have a measurements of where the body was, how it got moved, where it got, did it get twisted around? Did it get spun around, flipped around? They know nothing. They don't know where was he hit by standing on the curb? Was he 10 feet up from the flagpole? None of these details they can state, and they try to do it through Welcher for all that money for $400,000, and they got nothing to show for it. And he just basically blew up his own case right here. And so that's why right now, that's why the title of this is Brennan is so lost. He uses this Dr. Rentschler to prove that there was no SUV strike. That's how messed up in the head this guy is. Brennan, I'm talking about.
Wow. You can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do,
There's no evidence. Right there, he just said it. Where's the evidence? Where's it from Welcher? Welcher can't even say it. So think about it, guys. This prosecutor just brought out that his own expert, the only one that says of all the witnesses that testified in 31 days, it's the only one that could tie the car to striking John O'Keefe. And now he just basically tried to impeach this witness with that information. But what he doesn't realize is that he just completely blew Welcher completely out of the water. He blew him to smithereens. He just admitted they don't know what happened. They can't take anything to say how a vehicle strike happened because there's no evidence of a single witness, not even an expert for the Commonwealth. That's how bad he just blew up in his face.
a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision.
You can't replicate an actual collision that is proven it wasn't a collision. You have no evidence.
That wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm gonna, very briefly.
This guy is so set on badgering and browbeating people that are the most highly qualified experts you can find. And when he's doing this right now, that he's trying to say, basically, you had garbage information and you're trying to come up with a conclusion that's not garbage. He basically disproved it. You got garbage for evidence, Hank. You got nothing there for Welcher, and yet Welcher's just standing up there and rubbing blue paint, slapping blue paint on his arm and bumping himself like bumper cars in the back of that tail light of that SUV. I mean, this is like unbelievable. And this doctor even is trying to say that's not a scientific test, and the judge and prosecutor keep that out. So the jury's got to get this. I cannot believe any jury in America would fall for this absolute scam. They're being scammed right now.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment?
He did it at trial. This guy's sequestered from looking at the trial, but he did it at trial, Brennan. You know that.
Identifying the details of how Mr.
Unbelievable.
O'Keefe was standing, moving, or holding his arm at the time of the collision.
He did not state that. That's correct.
So when you've made your criticisms, that you've done testing regarding.
So no one from the government represented how this happened then. They got nothing. No details. Yeah, Karen put it in reverse and hit him. We have no idea where the hit happened. We had no idea how it happened, where he was standing, where he wound up, how his body was twisted, where he landed, how he landed, all those kind of things. They don't know anything. Yeah, it is sort of like burden shifting here, the way he's accusing this guy is not being able to solve it. They haven't even solved it. And now he's picking apart his own expert's report that they were able to trick the jury and try to slip it past her, that he made it sound like, yep, this totally lines up. And that's why he's doing the demonstration, because he's seeing this all lines up. The injuries all lined up with the back of that tail light, exactly how he had his arm at a 90-degree angle. And this guy's walking this back. Oh my gosh, if the jurors don't get this,
Dr.
good
Welcher,
night.
You don't have any evidence. Any statement by
Why even have trial? If she gets convicted, why even have trials anymore up in Massachusetts? Just take people that are arrested, line up on the wall, and just blast them away. You don't need a trial.
When I did that, there was one test with the
Just
arm like
execute
this.
him.
That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically,
Yes.
Dr. Welcher
He's
said in
walking
his
away.
report,
He's walking away always when he gets hammered with an excellent explanation by this doctor.
on page 9, He said,
He's always trying to look at him taking the notes here. He's not even listening to him. He's listening, but he's trying not to listen because he knows he's getting blown up to smithereens. So look at what he's doing with his pen.
that I have conducted an accident
Moving
reconstruction
papers
and
around, he's gonna
biomechanical
open it up,
engineering
but you don't do
analysis of
that. You don't do that when you're cross-examining witness. He's doing it to try to stall, make it look like this is not hurting me. This not hurt me. I'm going to try to distract. So imagine this: you got this so-called judge up at the bench shuffling papers, moving stuff around, and making all this noise, and looking at her phone, and making signals to the prosecutor. That kind of stuff's going on, and then you got this guy shuffling papers. I mean, what kind of a chaos circus is this?
this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine
He's not writing anything down. He's just drawing diagrams.
and where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical
Nothing.
causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I can.
Wow.
I believe I answered at the beginning of.
Yeah. Let's go back. This is such a brilliant answer. Let's not focus on Brennan now. Let's focus on the answer. But I'm glad the camera coverage caught this slickster stuff going on.
Any statement on it that he was trying to reenact the actual collision?
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case.
Blue arm.
I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report
Yes.
on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis.
So his report is worthless. His report is absolutely worthless. This doctor called it out. And you know what? Thanks for having him answer these questions, Mr. Brennan. Thank you so much. Thank you so much for doing that. And he's able to do this. Just blasted your expert out of the water on this. So thank you. Thank you for allowing him to go beyond the scope of what you allow the defense to ask these questions out of him. So you're actually doing a better job for the defense, and you're allowing the defense with your judge to rubber stamp all your objections. So thank you so much. Yes, it's beautiful.
He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you.
Other than your opinion, that's what he's testifying to. You're worried the fact that he's testifying to what you're failing to do and what your witness is failing to do. So
Again, my detailed question is, there is nothing in Dr. Welcher's
look
report
at Karen. They're all,
or in his
they know Brennan just completely is lost in the woods. He's actually helping the defense, and he keeps on badgering this witness, helping the defense.
any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that.
It's not stated. I'd be
He testified to it, and you're lying about it.
curious to find out if that wasn't the intent of the test.
That's the whole reason you called him up there as a witness. You think the jury's that stupid? You guys think the Commonwealth? You guys think the jury is that stupid? Are you serious?
Curious to see what the actual intent was.
Is the answer no?
So why were you replicating the back passenger taillight then? Why were you talking about those injuries to the arm exactly would come from the plastic taillight pieces that broke off without describing that in any detail, I might add? That's what you had him testify to, Brennan.
It's not in there.
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again. Is the answer no?
The answer is no.
Unbelievable.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
I don't think I've ever seen someone botch their case as bad as this guy is. I mean, it's over and over again. He's just digging himself a hole, digging himself a
My
grave.
question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no.
No, neither were you. Neither was Welcher. None. You had zero witnesses except the culprits that actually did it.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's, can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift,
Yeah, what if he said that? Yeah, no matter how many times, no matter how many ways you try to ask a question, my answer is still no.
if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
What's the guy
That
doing?
wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
Maybe if you answer my question.
Yeah, he's sick of your he's sick of your treatment of him, demeaning treatment of him.
Have you seen crash tests with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash,
Yeah. He's maintaining his composure, but you need to push back, just like the previous expert did.
crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision.
You can't even explain what happened to John O'Keefe. You're talking about other accidents?
Isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentschler's
Yeah, he's like Wile E. Coyote.
PowerPoint, please?
Keeps smashing into things. Intentionally messing up this case.
In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes,
And you put snippets up on the board?
yes.
And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those are the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many.
Yeah, because you got the lower front hood of the car that can help flip somebody and catapult them over the car. You hit a tall SUV like in reverse, if that, like Karen's vehicle, if you hit somebody backing up, you don't have that lower scoop out for the hood to flip somebody up in the air like that.
Sources where it talks about
It's not
front
relevant.
end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority,
Yes.
it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's the center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get
Excellent.
back to my question. When the tests
He answered the question. You're just
were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No,
Good
that's,
test.
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know.
See, he went from being able to only see on direct, whether it's consistent or not with John's injuries. And now he's able to actually say, as a matter of fact, it never happened. That's how Brennan just completely lost it.
The angle of his body at impact, do you?
The alleged angle,
Yeah, the alleged angle. No one knows it because it didn't happen. You can't say it.
So ask the question again.
Okay.
Yeah, because she wasn't listening. She was doing online shopping or something, maybe.
You have no information about the angle of Mr. O'Keefe's body at the time
He just
the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? Okay. Let's try slide 56.
Hey, I'm under a tornado warning right here, right now. It's like 10 miles away. It's
You would
headed
agree
right
with
to
me,
our
Doctor, there's a
direction
difference
here.
between a
So
concentrated
got to
and a
shut this
distributed
down.
load, wouldn't
We're
you?
told to go to a
I would,
basement.
yes.
When you gave your opinions in this case, it was based
I'll
on
let the-
concentrated load,
Keep
wasn't it?
playing. You guys
No,
can
sir.
chat. I'll try to
When you
come
gave
back.
your
Close
force
to last
equations, was that distributed load
Let's be over
or
within the next
concentrated load?
10, 12
But
minutes.
that was
I'll be
the
back
load
then.
at the center of mass. And so you can evaluate that on the distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer
But
was.
this was not a center of mass impact.
But we're assuming center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But
the
center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There was a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis, you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow
Did you consider phone temperature, battery temperature data?
Objection.
I'm gonna allow it.
Has nothing to do with biomechanics, sir.
I'll ask again, did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's in a,
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight was shattered?
I have, yes.
In fact, in your videos, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight
Well,
cover.
when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is,
When you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none. So, no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 99D. Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had taillight shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's sweater or shirt?
Objection.
I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat it than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and t-shirt was scraped?
Objection.
I'm going to allow that.
I need to see first.
Jurors, this will be brief.
in your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
I'll try again.
Okay.
When you looked at these taillight shards that were projection,
Go ahead, Mr. Brennan.
when we looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes? Objection. Same objection.
I understand the objection. Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're
I don't
telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred.
Right.
In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of the
I cannot believe how many days of trial, last year's trial, this year's trial, all the money spent. And the case is absolute garbage. And that the Commonwealth is just driving this stupid train down the tracks, just stuck on this stupid mindset that they think that people can believe that they're going to be able to convict her on evidence that proves she's not guilty. All this evidence proves she's not guilty. I just don't get it. But that's what happens when you're in a corrupt sector of society.
those broken pieces of plastic are sharp?
They
Here.
look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
We'll take a look. Objection.
Sustained.
If you look at that for me kindly, tell me whether you think those pieces of broken plastic are sharp. Objection.
I'm going to allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope.
Yeah, the tornado's watch is over. They actually had seen a tornado about, I guess, 10 miles from here or something headed this way. That's why National Weather Service was saying to take cover.
When you actually put things under a microscope, it looks much different, and it is much different than
Let's go back
Been
to
looking at the normal eye.
20E. Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
yes.
Shark's
think-
tooth.
Doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those shark pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could
Yep.
you go to video E, please?
That's what I'm saying. So Brennan is so out of his game that he's going to object to stuff that defense is trying to bring on direct. And then he turns around and just like completely brings everything in that he's been keeping out. It just, and then he keeps burying himself, keeps asking questions that just completely put him 6 foot under and completely bury him with 6 feet of concrete above him.
Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test we did, yes.
Is there a glass in Randy's hand?
There's not, no,
A drinking glass? No?
no.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes and that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this
Yeah.
test, but you move the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
No, I'm going to allow that.
You do not know how John O'Keefe
No one said how he's standing there except for your Welcher blue man, Brennan.
was
Unbelievable.
standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No,
You would not know the exact speed of any vehicle that hit him that night, would you?
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
what do you mean consistent or
Is it
different?
all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
16 more
If the
minutes.
dummy fell right there, no, they would not.
Cross.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light at what you say is 24 miles per hour can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot
Good
caught on
one.
a curb, sneaker come off, and then stagger backwards and fall on their head?
Now he's just making up wild stories here.
I'm going to allow that.
I'll allow that. Of course. This is not a
Doctor?
court of
Can you
law.
answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening.
Yeah, just including aliens. Maybe he got abducted by aliens and then got dropped, slammed back into the earth. Maybe that ridge he hit in the back of the head was when he's being levitated up and hit the top of the spaceship.
You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults in the front yard of 34th Fairfield? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you.
Yeah.
He did somersaults into the front yard.
No, there's no evidence of what he did.
Your Honor,
Look at- he's-
Dr.
he's like-
Okay.
I'm so sick of this garbage. Yeah. That's what he's trying to argue, though. All this, it's just crazy talk is what it is. If this goes to 19, it's going to be less than that here. And then we got there's a swivel chair.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you
Yeah.
consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
I'm going to allow that. I'm going to allow that.
I'm going to allow that. I'm going to allow that. Not overruled. I'm going to allow that. I'm going to make it
Objection, no.
personalized.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Are you aware of that? So, hold on, Mr. Jackson. Mr. Brennan.
I can
do you have a
reword
quick-
it.
He never says that to the
You're welcome.
prosecutor.
Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment
How did you know
about
that?
collision where that came from?
Where did you get
Well, I
the
did
info?
evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Yeah.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was
Doesn't
found in the
matter.
vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area? in front of 34 Fairview Road?
Yes, sir.
98, please.
Yeah, so if you stop thinking about it, Brennan's walked back his theory on how the crash happened. The one that described how it happened was, for the prosecution witnesses, was Welcher. And now he's saying the one demonstration he gave for how the injury to his arm happened that explained how then he would have fallen back and hit his head. All that is explained by Welcher. He's the only one that got to explain that for the prosecution. So now he's saying that wasn't a replication of what the engineering and physics and science is showing. So they got nothing. He just completely obliterated his theory. It's unbelievable. I've never seen a prosecutor just basically flip a defense witness into crushing his own case. Unbelievable. But when all you're doing is peddling spins and deceptions week after week after week after week, been ongoing since 22 April, you can't keep track of all the different lies, apparently. So you accidentally trip yourself up and start exposing your own lies here on The Last Witness. All right, let me play.
A little more, please. Do you know what that is, sir?
It's hard for me to tell from.
Is that like a drinking straw?
Okay, the black, that does appear to be a drinking straw.
Have
Yes.
you seen that before?
All right, something happened here. What am I doing?
I've seen that photograph before.
Why is it going fast? I just got to go to speedy.
And you appreciate that is
Oh, the mic is on the, got pushed on the keyboard. Sorry. Let's see this normal speed. Okay.
in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
Were you eating a ham sandwich?
But was it before you came and testified last time, or was it before this time?
Think in relation to when you had that ham sandwich.
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
What were you eating for lunch that day?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence.
Well, tell me which week or month ago. I want to know. This jury has a right to know.
When I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I'd known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so.
He's trying to get at the fact that how would you have heard about Karen Reed talking in the interview on, I think, a ID documentary when she talked about that she found John had some piece of glass in his nose. She pulled it out and blood was gushing out. So that's what he's trying to find out. How did you know that? Because that wouldn't have been in your discovery file from last year. So when would you have gotten that? Did the defense give you that information? He's thinking the defense probably didn't give him that. So my suspicion is that he probably saw it on the actual show itself.
Or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination
Never
whether
seen.
you denied that receiving information certainly help prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
She just laid on spring cleaning here in beginning part of June, doing housekeeping there.
Yeah, approach.
Yes.
Yep. Nothing there. Oh, now we got a flood warning.
Yes. 124
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
Hopefully it's not a copy and three again.
For a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes. Or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform
Look
me,
at-
yes,
look at-
about testimony.
Look at the judge. She's ticked. She's ticked at Brennan. You lost this case. How am I going to face the public having this? Just I've done all this dirty work. I've been carrying all this water, protecting you, and you completely went way beyond the scope of direct and brought out all kinds of things of this witness that the defense never dreamed about bringing out, because I would have objected just like I did before and during this whole 31 days. And now I hand you the perfect gift and you got to screw this up. Look at her. She's mad. She's thinking this is acquittal. Just got acquittal all over it.
In situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
She looks nervous. She should be.
125, line 7.
This is her legacy right here in the making.
I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question.
They ought to have a camera in every trial she ever has from now on.
Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on
Nice
during the trial, yes.
Preparation. Misleading the jury on actual evidence you had suppressed. You turn around and then mislead them and try to make it look like they're being underhanded and snaky. Well, do you guess what? That's underhanded and snaky on your part.
I have no further questions.
All right. Mr.
Finally,
Jackson.
wow, you really ended on a strong note there.
Okay.
Wow, what brilliant cross-examination. Thank you, Mr. Brennan. Thank you for allowing all that damning evidence to come out. He just didn't get to talk about whether something is consistent or not with your theory of the case, but you actually helped him prove that you have no case. You actually used him to impeach your one and only expert witness that you used to demonstrate what happened. Your Blue Man demo, you used this witness to try to impeach that, and you brought out all of his reports. Says he never said that this is how it happened. He never said this is how it happened. But yet that's what you demonstrated in court. So you know what? You just killed your one and only theory you had of how he died, and now you got nothing. You got absolutely nothing. And so you went from that one theory, so now you have no theory. You went from one theory of how it happened to zero theory. I've never seen any attorney, civil or criminal, completely do a face plant like this. I mean, this is even worse than the Blue Man demo, what he just did. This is like a huge, embarrassing. I mean, it's like, what has he got? Dementia, amnesia, or something? Did you forget that you're supposed to represent the prosecution? Yeah, when she's looking at him like that, it's like, dude, you're done for. You messed this up.
May I inquire?
Yes.
Thank you.
Where's Paul?
Dr.
Did he leave?
Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
Okay, so this now here
They is no one associated.
is 8 minutes.
Correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for
To,
that.
to get through this, I'm going to let you just
Thank you.
answer the question.
Sorry,
Mr.
Ron.
Rentschler.
And with regard to, and I appreciate that. Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car
Faster.
and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where's my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up. If it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F is in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown
Man,
several
how painful. Yeah, so did
photographs,
I.
exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic.
Karen looks
it's red
relieved.
plastic, correct?
That's correct, yes.
Shirley's coming to an end. She's expecting good results.
In your review of all the data,
There's
in this
just no
case,
way this cannot be not guilty across the board.
do you know
There's no way.
when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, they're claiming the abrasions are a result of the fractured taillight. It has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by.
It's not going to go
the
90
person.
degrees.
And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than.
He's saying if there wasn't a collision, but he's already said there was no collision. There's zero evidence of that. And that's massively a great thing that Brennan brought out. So thank you again, Mr. Brennan.
And if you can't explain how the impact occurred, if the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. It's scientific.
That would have been objected to if he had tried to brought that out on direct. But again, thank you for Brennan. Got to bring it on and cross. And now you got to bring it on and redirect again. I think he's just melting into his seat right now.
Typically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Sustained, you have to watch the formal question.
Of course. In your
That's a really good idea by Mr. Morrissey to have a defense lawyer come in here and create all this reasonable doubt. And just when you think, it's going really bad for the government, at the last witness for the defense, he just totally dismantles his whole case, the one and only witness he had to say what happened.
expert opinion, based
Love
on
it.
all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that. Be honest.
Remember, he talked about 4 times. I wrote it down 4 times. Talk about details matter. Details matter. Yeah. And then you go to the end of your questioning and you basically get him to say how, yeah, there's no details that your expert gave in this case. That is just so poetically.
In your view, was there evidence of a collision with John O'Keefe?
Sustained.
Is already asked and answered by you, Brennan. So why are you objecting
In
now?
your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck?
That's a
by
weaker
several bullets?
question.
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
He's already said there's no way. So thanks, Brennan. All right, then we got. There's a sidebar here coming up.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
I know sidebar.
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered. That's correct.
Do you know or understand that? Did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
See the judge.
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review?
Got to know this
about-
thing's toast.
What evidence would there be? Is there a video or a
Game
photograph,
over.
you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
Yep. Got the Brennan Blues here trying to trying to survive this onslaught of just insanity here. All right, there's a few minutes here. We'll jump ahead and get this thing wrapped up. Here we go. It's only 3 more minutes here. Let's see what other good government case killing questions
You were asked
have.
about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you
You got any? Well, that'd be funny if you say, "Do you got any photos with where those were found in relation to the body?" No, he's got nothing.
ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Yeah, that's a really sort of a dumb question to ask because it's so confined because it looks like it's planted. Yeah, it looks like it's planted. A debris field would have been much more spread out, and it would have been close to the body because that would have taken a 90-degree turn.
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
Oh, now it's in different areas. Which is it? A tight shot group or a wide one here, Brennan?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, they would
How could a leaf blower be searching the area? Let's back up.
in different areas on the lot.
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
What?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Did you notice in the
So if it wasn't there, yeah, okay.
injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasions, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Wow, that's a real good one. Talk about not having common sense.
Well, you can sit back or step back and look at whether what's
Now he's trying to have him walk back all the science he's been brilliantly talking about, and just well, really, isn't it just common sense? Don't just throw out all the science stuff you've been explaining in exquisite detail, all the physics and kinetic type stuff. I'm going to try to just beat you over the head with common sense.
someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics, it's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up.
That's common sense.
That's kind of the smell test, bigger picture. That doesn't make sense. But the physics.
Yeah, there you go. He just blew out another point. Brennan, man, you're doing excellent defense work. Thank you so much. You're awesome.
You can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary. Is one of your answers that you were all celebrating, isn't it?
Objection.
Celebrating? What?
The objection sustained.
I bet
Wait, was he talking about a ham sandwich? Celebrating eating a ham sandwich again?
laughing about in the documentary is one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection
Is he talking about celebrating with the defense counsel or something?
Motion sustained.
How'd that feel like break, sir?
How to break that, man?
The judge sounds like she's just totally exasperated. Just you've messed up this case. I did everything I can to block the truth from coming out, and you still got to screw it up, especially with this last witness.
Oh, I don't know. There's no evidence of how it broke.
Come on, can't common sense defy law of physics?
All right. You're all set, Dr. Rentschler.
Thank you, Your Honor.
Because that's what he used to do, and I think his whole career has just probably been badgering people, bringing up wild spin stories. I mean, if you got a case you can't win as a defense counsel, and he's taking it to trial, then all he's trying to do is drag stuff out and try to throw confusion in the way of witnesses and just talk a bunch of gobbledygook. So, anyway.
Is there an objection?
I don't know how any attorney could ever win a case acting like he's acted. I don't care, even if he was switched to the defense. All right, let's see here.
So, subject to us discussing it. Mr. Jackson, subject to me taking a look at it and us discussing it. It's not coming in right now.
She looks defeated.
Okay.
Look at her. She's like, you messed this case up. Yeah.
They've been marked for identity.
What kind of knucklehead impeaches
wanna see
your own
what's-
expert with a defense expert? You did a better job. I would have blocked all the truthful questions from coming out. And you just totally screwed this up. Unbelievable. Yeah, she's in shock. This is unbelievable. This is like the biggest part of the whole trial. The way he set him up to just absolutely demolish his own one and only expert. So anyway, it's awesome. Let's see here. They're gonna. So basically, it's 6:45. Brennan instructed by the judge to look at the Rentschler's PowerPoint for 10 minutes. They're arguing about the PowerPoint's admissibility. And then here, let's go to 7:17. This is where the great news is.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
Your Honor, it's late in the day. We would like to renew motion for required finding of not guilty at the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning.
Oh, thanks, Coach.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would,
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So,
The technical thing is we need to move in the 3 items of
There's a real somber mode. It's like everybody knows the gig's up.
PowerPoint is in evidence.
So Brennan is.
so Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and
Yeah, no, there's
you want to put in evidence, the videos, just the
no more
videos,
testimony coming
let me
out,
know that.
folks. So basically,
All right,
what's
so we'll
going on?
give you
I'll just jump
tomorrow.
right to it here. What we have is a charge conference tomorrow. So that's going to discuss jury instructions. I already talked about jury instructions 2 nights ago. They're trying to have this whacked out instruction saying that you can infer Karen Reed's guilt because of the fact that she intimidated and harassed witnesses or words to that effect, which is not even anything that is remotely what was brought into this case. And then we have, but who knows, maybe the judge will bring that up and allow that instruction. Anyway, that's 10 o'clock tomorrow, so no jury tomorrow for Thursday. Friday morning are closing arguments, and they're going to advise the jury. So this is going to go to the jury, according to what the judge is saying now, on Friday. And Jackson asked for 90 minutes for closing, and the judge said maximum 75 minutes, but she will think about it. Or I think she said something like it's a stretch to even ask to grant 75 minutes, but she will think about it, quote unquote. So yeah, Brennan folded all right. Folded like a cheap lawn chair. He knocked it out of the park for the defense. Yeah, I think it should be televised. I haven't heard for sure, but I imagine it's going to be televised. I can't imagine it wouldn't be. Yeah, so anyway, I just think that if we have a normal jury, I'm just telling you guys, if this was a normal jury, there's no way she would not be acquitted across the board. I feel like I have a really good judge of jury cases, and I'm not as good as if I'm actually sitting in the courtroom and actually reading the jurors. So I'm doing this all without seeing any of the jurors, but I'm looking at the evidence. I'm looking at credibility and stuff. So I'm just telling you, this is a slam dunk acquittal across the board. So if it's a hung jury, it's going to be maybe one person, maybe two at the most. I can't even see that. What normally happens with jury cases is that normally there's not always 12 across the board that are going to say, yeah, not guilty. But there may be a couple, maybe 3, 4 say, yeah, I'm not so sure. Let's talk about it. But I think these people that see what an outrage this is, they're going to convince the naysayers of why there needs to be a not guilty verdict across the board. Yeah, you thought that last time, okay, but keep in mind you had a cop on the jury. So as long as you don't have some kind of outlying guy that can basically talk every juror out of common sense, where it says, no, that's not here's what's going on. There's what defense is trying to do. They're trying to basically be an expert and trick the jurors into thinking a certain way. So and then the jury members are thinking, well, if this guy's a cop, he knows what's going on. I better not be tricked by the defense. That's what I've seen happen before. Is you get some guys in there that are just absolute maniacs to convict, and they'll convince all those, hey, I've been through this before. Hey, I know this is what they do. They'll talk crazy nonsense and get all these jurors paranoid to try to convict. Okay, Shirley A., you're saying you saw a comment from Nick Rocco on LTL's chat earlier. He said he was with the defense team tonight. They were doing their closing. Said it's going to be epic. Good. It should be. They should be probably Friday morning, 9 o'clock is my guess. They didn't set a time. All right, with that, I'm going to go ahead and shut it down. Thanks for your support for the justice matter here of Karen O'Keefe being railroaded, set up, framed, you name it. But the truth is going to be revealed here. So keep praying for that truth to come out and for her to go home and have a wonderful Father's Day with her dad, knowing that this whole nasty nasty outrage is behind her. So with that, have a good night. Be safe. And I plan to maybe cover tomorrow night on the charging conference. It shouldn't last as long. So maybe I'll jump on at 9 o'clock or so. So anyway, good night. Thanks so much.